So good afternoon, students, faculty, members of our community. For those of you who I haven't met yet, I'm Carrie Abrams, the Dean of the Law School, and it is my great honor to get to introduce this year's David Lange Lecturer, Jessica Littman. The Lange Lecture was established to honor Professor David Lange, who retired from the law school in 2015 as the Melvin G. Schwim Emeritus Professor of Law after 44 years on our faculty. A beloved teacher and renowned scholar, Professor Lange specializes in intellectual property, copyright, trademarks, unfair competition, and entertainment law. He is particularly well known for his transformative work on the public domain, including his 1981 article, Recognizing the Public Domain, and a 2003 article, Reimagining the Public Domain, both of which were published in our very own Law and Contemporary Problems. Prior to his retirement, this endowed lecture was known as the Kip and Meredith Fry Lecture, and in recognition of his career and contributions, they renamed it in Professor Lange's honor following his retirement. Professor Lange is here today, and please join me in recognizing him for his many accomplishments. There could really not be a more appropriate scholar to deliver this year's Lange Lecture in intellectual property than Professor Jessica Littman. Professor Littman is the John F. Nichol Professor of Law at the University of Michigan School of Law. She's the author of Digital Copyright and the co-author of a leading casebook on trademarks and unfair competition law. Professor Littman has told me she dislikes long introductions, and you have a very long bio of her in your lunches. So I'm not going to relist all of her numerous accomplishments. But I will mention that although Professor Littman is a professor at a different university, she is very much a part of the Duke Law family in her work on intellectual property and the public domain. In fact, her work and Professor Lange's work have intertwined throughout their careers, and they have been an intellectual conversation for years and years. Although they don't always agree on the specifics, they both understand the place of the public domain as being a space for fostering and protecting creativity. And indeed, Duke Law School has been really the center of work on the public domain and the home of the Center for the Study of the Public Domain. And I see sitting in the audience its current director, Professor Jennifer Jenkins, as well as the faculty co-directors, Professor Jamie Boyle, Professor Jerry Reichman, and Professor Artie Rye. I am deeply honored to introduce Professor Jessica Littman.
So I'm really honored to be here. This really is a center of very important leading thought on how intellectual property affects knowledge and information. And so it's lovely to come and talk to this kind of audience. So the title of my lecture is Before and After the Copyright Wars. For those of you who aren't copyright nerds, by copyright wars, I'm referring to the conflicts over the scope of copyright law that exploded when copyright law met the internet. So I'll tell you a little bit about what the copyright terrain looked like before those conflicts broke out, and then I'll say a little bit about how foundational doctrines have changed since then and where we might go next. I'm mostly going to skip the middle part. So there are a number of persuasive theories about why we have a copyright system and what purpose the laws in that system should serve. But something that all of the theories have in common is that the essential characters in the story are the author and the reader, the creator and the creator's audience. We might need publishers, bookstores, record labels, movie studios, broadcasters, search engines, platforms, and other intermediaries to make the connection between creators and audiences, but there's no reason in copyright theory or policy to favor particular sorts of intermediaries over their competitors, except on the basis of how well they do their job of helping authors communicate works to the public and helping them earn a little money when they do so. But from the very first copyright law, the power to control and shape the system and the laws has been in the hands of the intermediaries, who have used that power both to enrich themselves with rents taken from the pockets of authors and readers, and also to make it difficult for new upstart businesses to compete with them. And that was true of the Statute of Anne, it's true of the Music Modernization Act, and almost every copyright statute between. When new technology threatens to disrupt extant copyright business models, whatever they are, the dominant intermediaries reasonably perceive that as a threat and try to use copyright law as a defensive or offensive weapon to prevent the disruption. And as you can imagine, as new technologies go, the internet was scarier than most. And it inspired ferocious disputes. So when people started calling this disagreement the copyright wars, I think they meant the label ironically rather than descriptively. But over the years, positions hardened, rhetoric got more extreme, and partisans began to see each other as enemy combatants. And somewhere in that whole escalation, the phrase stopped seeming so ironic. So Duke's Center for the Study of the Public Domain is, in a very real sense, a child of the copyright wars. Duke faculty had been, of course, studying the public domain before there was a center. Professor David Lange had been thinking deeply about the public domain for 40 years, way before it was fashionable. Professors Jerry Reichman and Arnie Rye had devoted significant chunks of their scholarly careers to thinking about the effects that intellectual property laws have on innovation and scientific knowledge. Professor Jamie Boyle was one of the very first copyright scholars to realize that copyright owners' responses to the perceived threats posed by the internet could have severe consequences for our information policy. Now, what most of us legal scholars do when we see a very bad thing about to happen with the law is we write an article complaining about it. We publish the article in a law review, and then we sit back and wait for the world to appreciate our perspicacity. At the very beginning of the copyright wars, Professor Boyle decided to take a more active role. He talked with reporters, he wrote and placed opinion columns in major newspapers. He sat down with a group of fellow travelers to plan a strategy to oppose the expansion of copyright law. He wrote me and Jerry Reichman into that effort. He was good at it. Not good enough to actually convince Congress, but good enough to make some powerful people really angry. And 15 years ago, armed with the experience of fighting the copyright wars, that inspired him to set up the Center for the Study of the Public Domain here at Duke. And Duke law students and faculty have been doing really important and influential work ever since then to raise awareness of the importance of the public domain and the real-world effects of copyright and other intellectual property laws on the lives and work of creators, readers, listeners, and viewers. So I happen to think the end of these copyright wars is in sight. I don't know that many people agree with me, but when the conflict got going, the dispute was billed as an existential struggle between authors who needed to get paid and members of the public who wanted to enjoy their work for free. Now, I don't know. It's very hard to assess whether that was sincerely what people thought or just rhetoric. But in 2018, the active conflict is no longer about either creators or members of the public, both of whom have kind of gotten kicked to the curb. Rather, what we have going on now is a fight between old-fangled intermediaries, by which I mean publishers, movie studios, record labels, broadcasters, and newfangled intermediaries, platforms, search engines, streaming sites. And what they're fighting about is who gets how much of the huge sums of money that are sloshing through the system. They're all basically big corporations with lots of lawyers fighting about dollars and euros and pounds. And the thing about fights over money, at least if the combatants are evenly matched, no one's gonna file bankruptcy if it loses, is it's almost always cheaper and easier to resolve the fight by moving money around than it is to pay your lawyers to fight it out in court. And sure enough, what we're seeing is these companies are resolving their copyright disputes by buying up pieces of each other. So I realized recently that the copyright wars have been going on for nearly 25 years. That means for many of you, copyright law has been deeply polarized and contested territory for all or most of your lives. So since I was coming here, this seemed like a good moment to assess what the copyright wars have wrought, what's changed as a result of the last 25 years of conflict, how much difference have those changes made, what should we expect going forward, what choices should we make if we don't like what it seems like the future is serving up. So I want to stress a couple of overarching themes. First, as I'll tell you, as many of you know, there have been major changes in the fabric of copyright law in the past 25 years. But the changes affected by legislation and court decisions have been surprisingly modest as compared with the changes that have evolved outside of the congressional or judicial lawmaking process. Those changes have been huge, but they're also much harder to see. Second, one of the reasons I think we fail to appreciate the scope of these sorts of legal changes is we all look at law and history and copyright history through the lenses of our cognitive biases. And one of the most persistent of those biases inclines us to assume, not so reflectively, that the baseline premises and concerns surrounding past or future issues are, were, or will be essentially congruent with the premises and concerns surrounding those issues today. It's often not true. But we can see this at work when we look back at what major copyright owners were trying to do to make the internet safe for their then established business models. They had no idea what was coming, and they spent a lot of energy trying to solve problems that were different from the problems that ended up materializing. But we also see that kind of cognitive bias when we examine our understanding today of what was going on 25 or 40 years ago. We tend to assume that the essentials we take for granted about copyright law today were reflected in those past disputes. Again, as often as not, that's not what it looked like at the time, but the tendency affects even those of us who lived through the history and therefore ought to know better. That sort of bias just exerts a powerful gravitational pull. So let's rewind 25 years so I can tell you a little bit about the beginning of the copyright wars. The first skirmish in the struggle took place on November 18, 1993, in the Crystal City Marriott Hotel in Arlington, Virginia. I was in the room. The occasion was the first public hearing of a government body within the US Department of Commerce that had been given the bureaucratic name of the National Information Infrastructure Task Force Working Group on Intellectual Property. Okay, that's a mouthful. National Information Infrastructure was what the early Clinton administration called the internet. So President Clinton had tasked this working group with resolving issues of concern in the intellectual property area regarding the digital distribution of works of authorship, quoting the charge. So the working group announced a public hearing at which everybody who was anybody in the community of copyright lobbyists was invited to testify about just what were the big issues of concern in the intellectual property area regarding the digital distribution of works of authorship and how the US government ought to resolve them. When you go back and read transcripts of this hearing, you find all sorts of quaint, clueless ideas. A number of witnesses took the metaphor of information superhighway very literally. So here's one example. Douglas Bortz. Douglas Bortz is a scientist testifying for Adobe. He proposed that before any consumer was able to use the internet, he or she would need to get an information superhighway driver's license. And in order to get the license, he or she would have to pass a copyright test. Okay, besides what in retrospect seems like implausible silliness, there were a number of claims the working group took very seriously. Copyright owner organizations insisted that unless they were assured extensive control over their copyrighted works, the supply of useful information would be drastically curtailed because copyright owners would simply refuse to make their works available over digital networks. Indeed, the premise of the hearing was that nobody would bother to build the internet or deploy new digital networks unless they could charge consumers hefty subscription fees to give them full access to commercial entertainment and information. So if copyright owners felt that digital networks would be insufficiently protective of their copyrights, the internet would never get built at all. At the same time, as they said, we need lots more control. Almost all of the witnesses showed a curious reticence to involve Congress in amending the statute to enhance or clarify that control. So we need more rights. Let's not amend the statute. So what was going on there? Only a year earlier, Congress had enacted a copyright law called the Audio Home Recording Act, a now mostly forgotten law that sought to respond to consumers' digital audio recording. The law was the culmination of a 15-year campaign by copyright owners to regulate or earn royalties or prevent the sale of home audio and video recording devices. And members of Congress repeatedly signaled during the fight that they didn't believe the copyright law imposed liability on consumers for non-commercial copying. And sure enough, when Congress finally agreed to pass a law, it insisted on including a provision that senators and representatives believed would give consumers a complete exemption from any copyright liability for non-commercial home recording of recorded music. That provision, by the way, is still there. It's in 17 U.S.C. section 1008. Nobody pays attention to it anymore. So we're at the working group hearing. It's only a year later. And copyright owners were afraid that the enemy they were going to be facing was the ordinary consumer, let's call him Joe, who wouldn't see anything wrong with sharing his favorite entertainment with millions of his friends. On the one hand, they wanted very much for it to be not only illegal, but impossible for Joe to do that. On the other hand, they were very reasonably worried that if they took the problem to Congress, Congress wouldn't see anything wrong with what Joe was trying to do either. Maybe Congress would insist on inserting a provision that gave consumers a complete exemption from non-commercial copying over digital networks. That seemed really risky. So most copyright owners insisted that involving Congress would be unnecessary and unwise. But there was a major exception to this overall cautious stance. The recording industry believed it had a big problem that only legislation could solve. The recording industry insisted that under extant law in 1993, it had no legal authority to control the transmission of copyrighted sound recordings over digital networks. And unless Congress amended the law to give it more rights, they'd be helpless to stop Joe from transmitting their recordings to millions of his friends. After the hearing, the working group staff went to work to come up with ways to get the copyright lobbyists what they were asking for. So before I skip over what happened next, I want to stop and reconnoiter. So in 1993, at the dawn of the copyright wars, copyright bills, then as now, were for the most part written by copyright lobbyists and then introduced by some member of Congress. Senators and representatives, though, generally agreed that proposed copyright legislation ought to be examined to ensure it advanced the public interest, and possibly even revised before actually enacting it. Thus, the insertion of the consumer exemption into the Audio Home Recording Act. The law was seen as giving authors a collection of specific exclusive rights, each of which had significant limitations. So the right to reproduce the copyrighted work was a right to reproduce the work in copies. And what copies meant were material objects, tangible things you could pass around. The reproduction right didn't cover other unfixed or temporary instantiations of copyrighted works. There were performance and display rights that were limited in terms to only public performances and displays. There was a right to distribute copies that was limited by the first sale doctrine. This is a long-standing copyright rule that entitles the owner of a copy of a work to resell the copy or give it away. So imagine how high casebook prices would soar if this weren't the legal rule, if you couldn't resell your casebooks. So those limits secured consumers' rights to read, look at, watch, listen to copyrighted works and to transfer their copies to other readers and listeners. And everyone understood that copyright rights were limited in scope to allow readers, listeners, viewers, and also competitors to make a variety of uses of copyrighted works. And even though copyright owners didn't like it, this was generally seen as a system feature rather than a bug. Further, as I said, most members of Congress believed that the copyright law didn't, in fact, actually reach into people's homes to make them liable for non-commercial personal uses. Now, copyright owners disagreed with them about that, but they conceded that enforcing the law against home users would be impractical. Okay, so that was then. As lots of folks, including me, have told the story elsewhere, the working group sat down and wrote a report that said, we don't need to make major amendments to the copyright law, because if you only understand it properly, it already gives copyright owners everything they want. And the key to this new understanding was a breathtakingly expansive reinterpretation of the exclusive right to reproduce a work in copies, predicated on a very, very broad understanding of what a copy was. But the report didn't actually recommend amending the statute to nail that understanding down. Instead, it recommended what it characterized as a few modest amendments. It wanted to define the copyright owner's distribution right to include transmissions, solving the recording industry's problem. And it proposed a new amendment making it illegal to hack copy protection technology. And from those beginnings sprung a law called the Digital Millennium Copyright Act, which took another few years and a slew of dramatic and nasty maneuvering to make it through Congress. It ballooned from an initial draft that was 8 pages long to a 60-page amendment to the copyright law that contained lots of items that copyright owner groups had added to their wish lists. And passed in 1998, it seemed enormous at the time. In truth, the actual changes made by the statute weren't so momentous. Copyright owners got almost everything they were asking for. Record labels got an uncontroversial exclusive right to transmit the recordings over digital networks. All copyright owners got a law making it illegal to hack copy protection for any reason, whether or not the purpose of the hacking was to commit infringement. They also got a new expeditious way of causing infringing material to be removed from the internet. Instead of having to file a lawsuit and get a preliminary injunction, they could send a notice to the online service where the infringing material was, and the service would take the material down. So cheaper, easier, faster. And in return for that, copyright owners gave up an unrealistic claim that online services ought to be held strictly liable every time an infringing file was either stored on or transmitted through their networks. So the price of agreeing to the new notice and takedown regime was a safe harbor for online services, protecting them from liability for infringing content they didn't originate or control or know about. We all at the time thought that copyright owners had succeeded in staging a tremendous legal coup. They thought so too. As it turned out, though, they've had reason to regret the deal. And the problem is that copyright owners drafted their wish list based on a bunch of assumptions that seemed completely reasonable in 1993 but didn't prove out. Back in 1993, as I said, copyright owners thought the only good reason for a consumer to pay for internet access would be to be able to enjoy commercially produced information and entertainment products. They reasoned the only way to make a profit from providing internet access would be to sell subscriptions to consumers eager for the content. And they figured if they could prevent consumers from gaining unlicensed access or making unlicensed copies, they'd be able to charge us all lots of money to gain licensed access. And finally, they figured that devising a technological system to prevent unauthorized access or use was just around the corner. And if they made hacking technological protection illegal, that would effectively deter folks from doing things to gain unauthorized access. So as we now know, all of those assumptions were wrong. There was never going to be a silver bullet copy protection scheme. Circumvention tools are widely available. You can find easy to follow circumvention instructions in respectable newspapers and online magazines. Several major media companies have decided not to bother with DRM protection at all, since it costs them something to encode every copy, and that encoding doesn't, in fact, provide meaningful protection. So the publishers of interactive works, like the electronic game industry, have made effective use of the circumvention provisions, but for everybody else, they've been a bust. But while copyright owners were marking time waiting for the development of the perfect digital rights management, they delayed making their works available online. Indeed, they pursued a strategy of relentless litigation, suing any upstart business who dared to offer music or video over the internet or help consumers do it themselves. Book publishers, movie studios, and record labels were reluctant to launch less secure offerings, and they were also worried about cannibalizing their existing bricks and mortar business models. And so when they finally did start making their works available online, they offered pallid, overpriced digital services with terrible user interfaces. So there was a bunch of pent-up demand, and because copyright owners had sued all the upstarts into bankruptcy, there was no real competition when a few well-capitalized businesses decided it was worth it to take a litigation risk and entered the digital market with offerings of their own. So Apple, Amazon, and Google soon became providers of online music, books, and video that were willing to risk being sued. They faced very little competition, and they soon achieved market dominance and became obligatory partners for content owners hoping to release their material online. And online platforms figured out they could make more money by selling eyeballs to advertisers than they could by selling movies to viewers or music to listeners. And then Apple and Amazon and Google then proceeded to become impossibly wealthy. Copyright owners resent that. They've coined the term value gap to describe the injustice of the fact that platforms have too much bargaining power and can therefore shape the terms of copyright licenses to call for lower royalty payments than copyright owners believe they ought to pay. So it's not that platforms don't purchase licenses for the copyrighted content that appears on their services, they do, but because of their market dominance, they have the upper hand in negotiations and they can insist on paying lower royalties than copyright owners believe would be fair. Given how much money online platforms are raking in, copyright owners feel they ought to be sharing a bigger piece of it. So, the expedited notice and takedown method for getting infringing material off the internet was imagined by people who thought human beings would be able to use digital search technology to find all of the infringing files and demand they be taken down. So those people weren't conceiving of the sheer scale of the 21st century internet. It turns out that no matter how many college students you hire at minimum wage, human beings can't possibly screen all the material online. You need to program machines to do it. And while machines are not as expensive as filing lawsuits, they're not cheap. Then there are the online safe harbors. The safe harbors, first of all, encouraged online services to create platforms like Twitter, Instagram, Facebook, and YouTube that enable millions of consumers to communicate with each other. But if the expedited takedown procedures don't work on a massive scale, or are too expensive or too much trouble, that means that there's lots of infringing material available on these services posted by ordinary consumers, music to accompany their cats. But copyright owners haven't yet gotten it taken down. The material is only going to be there until someone gets around to complaining about it, but in the interim, it will attract eyeballs that might otherwise look at copyright owner authorized content. So copyright owners ended up with a lot less than they thought they were getting from the DMCA. That doesn't mean that bad things didn't happen. They just weren't the bad things that the bill's supporters or its opponents imagined. So when they were pushing the DMCA, content owners warned Congress that unless the copyright law gave them the tools to prevent online piracy, authors wouldn't be paid enough money to keep creating works of authorship. Okay? 20 years later, many creators report they're being paid a lot less than they were before. But the reasons for that don't seem to have much to do with piracy. Some of the explanation is that copyright owners appear to be trying to make up for the raw deal they believe they're getting from platforms by paying their authors less than they used to. Another part of the explanation is now we have new digital systems for paying royalties that rely on metering and tracking actual uses. And that has made what was already a troubling winner-takes-all problem even worse. So there are zillions of dollars in music royalties, but they all get paid to Taylor Swift and there's nothing left for everybody else. Now, those of us who tried to persuade Congress not to enact the DMCA worried about copyright owners locking up information so that the only people who would be able to see it were the people who were able to pay for it. That didn't happen. We've got a vibrant network that both supports consumer-to-consumer communication and offers myriad opportunities to enjoy commercially produced content for very little money. Now, that doesn't mean it's not expensive in real terms. It just doesn't cost money. People who want to learn the information or enjoy the entertainment or upload videos of their cats are paying with their personal privacy and data, which turns out to be really valuable both to advertisers seeking to sell us things and Russian government agencies seeking to steal elections. So an important reason the amendments to the copyright statute didn't work out the way the backers hoped, the opponents feared, is we were all assuming that the future would proceed on roughly the same premises as the then present. On the other hand, even though the statutory changes didn't end up making the differences that people hoped for or feared, we've seen significant legal changes that are completely non-statutory, largely non-judicial. And because these changes crept up on us gradually, they're difficult to see. In the past 25 years, underlying assumptions have changed. How could it be different? The meaning of important copyright terms have changed. And those differences affect our understanding of statutes, even when the statutory language hasn't changed. So we find ourselves acquiescing in changes in the law without fully appreciating how they happened or even that they happened. Now, back in the day, it was conventional to look at a law's legislative history to figure out what Congress thought it was doing and measure that against what we thought the language in the statute meant or should mean. But now that legislative history is unfashionable, statute readers construe laws according to their current understanding of the plain meaning of its words, without necessarily remembering that the meaning of words changes over time. So I mentioned the foundational principle that copyright gives authors a bundle of limited rights with ample breathing room for personal uses. That's no longer so foundational. The concept of a copy has expanded beyond the idea of a tangible thing, a material object, to include temporary and ephemeral instantiations. And that change didn't happen because Congress revised the statutory definition of copy. It didn't. The current definition is the same one that's been in the statute for the past 42 years. The change happened because copyright owners insisted, again and again, that the word copy had always been understood in this broader sense, and they behaved as if they were right about that. And gradually more and more people took their word for it. But what that means is that uses that used to be outside of the copyright owner's control are now treated as actionable because they involve copies. Copyright owners insisted that end-user license agreements are legally enforceable, even when they divest users of their statutory rights under copyright law. And again, this is not something Congress did. Copyright owners said it should be true, and then they said it was and had always been true, and then they insisted that denying them this ability would torch their investment-backed expectations. And again, more and more folks conceded, well, they might be right about that. So there have been some court decisions on this one. They've been mixed, but copyright owners are winning more than they're losing. When you combine those two changes, though, the once strong consensus that copyright law either doesn't reach or can't be enforced against individual consumers evaporates. And the blanket exception for consumer non-commercial copying of recorded music, while it's still in the statute, has been forgotten. Now, this doesn't mean that copyright owners have figured out a way to stop ordinary people from making personal copies, but they have managed to sell the idea to the general public that they would be entitled to do so if they figured out an effective approach. And then there's the first sale doctrine. Copyright owners claim the first sale doctrine should not apply to digital copies, both because transferring a copy by digital means causes an additional copy to be made on the recipient's device, even if the original copy is destroyed immediately. If that doesn't persuade you, they argue that looking or listening to a digital copy requires the device you're using to make a copy in the broader sense of an instantiation in the digital memory. And that gives copyright owners the power to use an end-user license agreement to make sure the owner of the copy can't transfer her right to make the digital copy necessary to view or listen to the work. So if that's right, there are effectively no first sale rights in digital copies. So these are some examples, but what I'm trying to illustrate is that the most successful and far-reaching reforms coming out of the copyright wars weren't statutory. Instead, they happened because copyright owners took controversial legal positions, insisted again and again that the law was on their side, and if necessary, litigated the question by choosing opponents who didn't have the financial resources to mount a robust defense. And through that campaign, people came to accept, at least as a practical matter, that consumer peer-to-peer file sharing is illegal. End-user license agreements are binding and trump user rights, whether those rights are recognized by courts or enumerated in the statute. The exclusive reproduction right is broad enough to reach any unauthorized digital use of a protected work. And then we forgot that the law had ever not been that way. I can't tell you how many frustrating conversations I've had with students and lawyers and scholars who have not so reflectively come around to the view that all of these new legal rules were at least implicitly baked into the statute 42 years ago, because that's how we've come to understand the meaning of those words now. So if a robust public domain is important to us, those are sad stories. So let me tell a happier story or two that relies on a similar underlying mechanism. So the first story is about fan fiction. Now, if you're looking at copyright from the economic incentive rationale, non-commercial fan fiction and other fanish creativity is an unmitigated good for copyright owners. It engages customers. It stokes demand for new works. It enhances the bottom line. Nonetheless, 25 years ago, almost all copyright lawyers and scholars agreed that writing and sharing fan fiction online would and should be actionable. That meant, among other things, that even if it were unlikely that Lucasfilm or Paramount would sue over unlicensed fan fiction because it was making them lots of money, proprietors of websites believed that it would be too risky to host the stuff. Today, you'll find lots and lots and lots of fanish creations of all sorts online. And you see widespread agreement that non-commercial fan fiction is, at least more often than not, legal. And that consensus happened because some determined creators of fan works decided to make it happen. So Harvard Law professor Rebecca Tushnet deserves much of the credit for this. Sometimes law professors really can change the world. Tushnet and some colleagues created an organization that treated fan fiction as a field of legitimate cultural studies. They launched a scholarly journal devoted to the study of fan creativity. And then they set up a website that promised to archive fan fiction and refused to take the works down even if copyright owners complained. And then the organization engaged in a bunch of legal advocacy, defending the legitimacy of fan fiction as a transformative use under the fair use doctrine, and basically persuaded everyone, even Time Warner, that that was the right answer. Now that seems like a very small thing, but it represents a shared understanding that readers, listeners, viewers, and other members of the audience have a legal interest in responding creatively to works protected by copyright. So it's not as small as it looks on first glance. I can tell similar stories about the Internet Archive and about publicresource.org. Very briefly, 25 years ago, almost all copyright lawyers and scholars agreed that copying stuff wholesale and posting it on the internet was clearly illegal. No question about it. Brewster Kahle believed that the internet could become a resource for universal access to knowledge. And in 1996, Kahle began to copy and archive lots and lots and lots of pages on the World Wide Web. His Internet Archive Wayback Machine allows anyone to search for web rot, material that used to be on the web but isn't there anymore. And the Wayback Machine has become a widely used resource for ascertaining what was available online when. It's used by students, scholars, lawyers, judges. A few years later, Kahle digitized and posted the text of lots and lots of public domain books and stories, which he identified by examining 20th century copyright registration records and then checking to see whether the copyrights had been renewed. Since then, he's expanded the Internet Archive to make it a comprehensive digital library. He copies and archives the texts of books, copies of media, games, software, many of which are still protected by copyright. And like a bricks and mortar library, the Internet Archive will loan digital copies of books in its library. Now, like other online services other than the Organization for Transformative Works, Kahle will remove items if the site gets a copyright complaint, and in 22 years, no one has actually filed a copyright suit against the site. Should such a suit be filed, Kahle's got a compelling fair use argument, and his work has helped to establish that unlicensed, unauthorized copying for archival purposes is often legal. Carl Malamud. Carl Malamud is a gadfly. He's an activist. He believes in broad public access to, among other things, laws, government documents, litigation records, and privately drafted but publicly enacted safety codes. So he collects such documents and posts them online at public.resource.org. Because he believes that technical standards incorporated by reference into laws are themselves laws, and that copyright shouldn't prevent him from making laws available, he refuses to take documents down when purported copyright owners complain. Now, drafting safety and building codes and then selling copies to people who need to comply with them because they've been incorporated into law is a very big business. So Malamud has been sued for copyright infringement a lot. He wins some and loses some, but most recently the Court of Appeals for the DC Circuit ruled that much of his activity qualifies as fair use. So why am I telling these stories? First of all, Congress seems less and less inclined to scrutinize copyright bills to see whether they advance the public interest. And professional copyright lobbyists have a raft of new tricks that make it more and more difficult for anyone else to remind Congress that the public has a crucial stake in the copyright law. The Music Modernization Act, which passed Congress in this past month and sits on President Trump's desk, was cleverly written to be completely unreadable. It appears to have prevented both the bill's supporters and its opponents from actually reading it. Makes it very hard to insist on an amendment if you just can't get through page 183. So if we're to succeed in asserting the public's interest in access to works and the freedom to make use of them, we're unlikely to make much headway in Congress. And so I take some solace from the maddening fact that so many of the changes that turned out to be really important were accomplished without actual change in the words of the statute, and indeed often without any judicial intervention. That means they're susceptible to being changed in the other direction by similar mechanisms. The fluidity that allowed important copyright doctrines to morph without change in the hard law gives us some room to morph them back. So the expansive definition of copy, for example, never made any sense, still doesn't. That makes it vulnerable to reassessment. The legal fate of the first sale doctrine is currently in litigation. The Second Circuit has been sitting on a case for a year. They will tell us what they think the answer is sometime. Meanwhile, though, the more people who buy copies of works by pressing a buy button and believe it means what it says, the more pressure they can bring to bear on digital sellers to actually sell them copies they can dispose of as they please. So the so far relatively modest successes of Tushnet, Kale, and Malamud in pushing back against an expansive understanding of the scope of copyright exclusive rights persuades me that that's a strategy we ought to be exploring further. In other words, we already know that persuading Congress to pass a law may not be the most effective approach to law reform. Sometimes a more effective way to change the law, to change the meaning of the law, to change the effect of the law, is not by changing its words, but by behaving as if it means what you believe it should mean. And with that, we've got only, I guess, 10 minutes for questions, less. I went over, I'm sorry, but I'll take any questions you've got. Jerry.
Difficult subject. I assume you're aware that pending legislation, or somewhat pending and somewhat proposed legislation on the internet in Europe is contemplating a filtering method, which in the 1990s they represented the national academies at the WIPO Copyright Treaty. That was the first thing they wanted, and that was the first thing we got rid of, and we thought was buried forever. And now it could could really become law. I wonder what you think of it.
So, I mean, copyright owners have made it a top priority to get rid of the online services safe harbors because they think, among other things, that would reduce the bargaining power of platforms and would get them some more money. In the United States, they tried to persuade Congress to do a redo of that a few years ago in the SOPA bill, which went down in widely publicized flames. But they have been more successful in their efforts to persuade the European Union to amend its digital directive to give online services some obligation to prevent the posting of infringing content. Now, you know, if that happens, it's going to be something of a disaster in the sense that, well, Google developed a content filtering software system that's pretty effective. Cost it millions of dollars. There is no reason to expect Google to share. But if online services have a legal obligation to prevent infringing content, then the only people who are going to be able to play in that space are the big boys who can afford to either develop or license content filtering. So that's going to cement the dominance of the current dominant service providers. This causes me some concern that when you get right down to it, they'll be just fine with the new digital directive because it will prevent the next Google from challenging the current Google. That's some of what I mean by moving money around. Yes?
What do you think is the biggest problem? Starting from the supposition that we want to get content from authors to use it.
So I think the biggest problem is that the copyright system sucks at compensating authors. It always has, but it isn't getting any better. So we have this whole system, and so far, people have access to all sorts of information, but it is less and less likely that creators are able to make a living. That offends me less from copyright policy than that I think people who do valuable work have earned the right to get paid. But when I try and figure out how to fix that, that's really hard. And I'm not at all sure that law can get us there. Certainly, the fact that copyright is a property right and the property right gets assigned to the intermediary who keeps it is part of the problem. But I've been starting to look at other ways that we could persuade or shame intermediaries into paying their creators more money than they do. Because there's clearly a lot of money there. It just isn't getting paid to the creators. Jamie.
Jessica, thank you so much. Wonderful talk. To me, it seemed like a closer run thing that they would end up with strict liability and a neutered internet, but maybe that was my own hysterical perspective. But my question is about where we are now, particularly in terms of music. I think you, like I, tend to first start to look at things through the lens of copyright because it's the most fascinating thing in the world. But obviously, a lot of changes have happened aren't to do with copyright.
Yeah.
I ask my students every year, Duke Law students, very law-abiding, if they have a friend who's ever illicitly downloaded music, and many of them do, which is good because we like to keep the edgy people, known to us. But I also ask them how they get their music, and now they all get it through streaming.
They do.
Right? They all get it through streaming. I mean, yeah, there's illicit stuff that their friends have on their phones, but frankly, it's unimportant. Through streaming. They also tell me that, and the data bears them out, that they go to many more live shows than people did 20 years ago, that they have favorite bands they buy merchandise of, et cetera, et cetera, et cetera. And you and I know that the marketplace for music, some money has gone away from some of the big artists, although not all of them, in getting recorded music compensation. A lot of more money is now going to people performing music. A lot of money is going to pro-am musicians, right? So we now have people who have music as a gig, but not as their main thing. The world has changed. Copyright had something to do with that. The technology had something to do with that. But it was a lot of it was kind of marginal. Isn't that world more the reason why creators aren't getting the amount of money that you and I would like to see them get, and less the failures that copyright law and the technology together have come up with in dealing with our current situation?
So I think obviously lots of things have contributed, but copyright has contributed too. Among other things, the fact that music and recording businesses are so angry at Darth Google that they're paying their artists a lower royalty rate than the lower per copy rate rather than the licensing rate, and they feel entitled to that. That's got to do with copyright and the fact that it's very hard to license music. I mean, if you want to be a law-abiding podcast producer, it's kind of impossible because of the way copyright has fractured music ownership and licensing. So I think that copyright law is indeed impeding clever people from solving this problem. And I'm cynical enough to think, yeah, that's one of the reasons we wrote it that way. Might have time for one more short. David.
Jessica, this was a wonderful lecture. Thank you. But you wouldn't contend, would you, that there is actually less creative content coming into existence in this time than has been the case in the past?
No, it's copyright. I mean, I don't happen to think that copyright's got a lot to do with encouraging artists to create that content, but the fact that it's now easier to communicate your creativity to other people has caused a great explosion in creativity.
And why should we worry about what they get paid?
So, as I said, I believe that if you do good work, you're entitled to be paid, whether you're building a chair or building a house or building a song.
But maybe not if what you're doing is writing poetry or short stories or novels.
also, I think if you're writing poetry or short stories or novels, you also ought to be able to earn a living wage. I mean, even successful playwrights cannot support themselves from writing plays. That strikes me as not good.
But just one more,
Yeah,
that's always been so.
it has, but
We have great plays.
we do. We have great plays, we have terrific music, good novels, decent poetry,
Written by the greatest playwright in the English language.
before copyright.
Before copyright.
Yeah. As I said, I don't think copyright is much of an incentive. I think a system for encouraging creativity, one of the things it should try to do is enable people to get paid for engaging in labor we all find is valuable. Okay, thank you.
Thank you so